about probates. And I know as a real estate broker, I'm out there showing property, they'll say, this is a normal sale, this is a short sale, this is a bank owned, this is a probate.
Correct.
What the heck does a probate mean?
Great question. So when you're looking into different real estate opportunities, they list them just like you said, all the different kinds. A probate basically is where the person that is selling the house is deceased. And a probate is the technical term for when there's a court process whereby the court goes out and first off you need a probate attorney to help you with it, but the court goes out and collects all the assets, looks at all the debts, pays off all the debts from the assets, and then hands out the money to the beneficiaries, usually the children or of the decedent. And so a probate property is one that is in what we call the decedent's estate, and it is handled by the court, and it does have kind of a lengthier process to deal with.
Now each county will handle that throughout California or throughout America, I guess.
Correct. So depending on where the property is where the probate will be. There's also some small situations. For example, some people may pass away in Santa Clara County but own property in Washington. And so in Washington, you'd have the main probate would be where the person passed away, but then the property that was, say, up in Washington, we would do what's called an ancillary probate, and there may be a mini probate procedure done in the county up in Washington to then bring the proceeds back into the main probate of Santa Clara.
Wow. So in other words, if somebody was just vacationing down here and passed away, would that still be the case?
Usually it's where they're domiciled, so it would go back to where the main real estate is, and there's rules depending on who the executor of the will is, or if it's a female, we call it an executrix.
Okay.
And one of the big misconceptions is that a will does go to probate. So even if you have a will, the will must go into the probate scenario. And I'm sure you've heard of the word living trust or family trust or revocable trust.
Sure.
Those documents, the main purpose of all those documents is to avoid probate. Probate can be costly and it drags out for a long time.
So for the lay people in the audience, the reason we have a probate is because there was not a trust involved.
Correct.
Okay.
That's one of the reasons, one of the main reasons. Because obviously, when you go to sell your property, if you're no longer with us, who signs an escrow?
Right. Okay. Now, you had mentioned in the past that everybody, if you don't have a living trust, you do have, I forget how you phrased it, you do have a
we all have an estate plan.
There it is.
And you may not even realize you have an estate plan, but you have something called the probate code here in California.
Okay.
And so if you don't have a will and you don't have a trust, you die what's called intestate. And that basically means without a will. And then there's a whole body of what we call intestacy law that covers what happens to the property and your quote-unquote stuff. Mm-hmm. And to sum it up quickly, most people's estate plans follow the laws of intestacy. So for example, the property would go down to the children, and if the children are no longer alive or there are none, it goes up to the parents. If the parents are alive, then it can go out to the aunts and the uncles, and there's a whole table where the money goes through a certain process. And then if the county cannot find any heirs to the probate estate, as we call it, then it escheats, or it actually goes back to the state of California.
Wow.
And so it doesn't happen too often, but I have seen instances of that happening. Mm-hmm.
Now, you had mentioned that it will be a probate attorney involved. So
hopefully.
Now, let's say old John, great old guy in the neighborhood, he passed away. No one knew anything about him really, but he passed away. And now, at what stage did the neighbors call and say, the mailman says we see all this mail collecting and John passed away? What happens?
Well, hopefully John has some closer individuals or relatives or people that come to his aid, right? So usually if you're talking about the sale of the house would come when the beneficiaries of John want to sell the house. At that point in time usually is when the real estate portion comes into it. But probates, a lot of times, we do many probates that occur many years after the person passed away. For example, it's not uncommon to have, for example, maybe an elderly parent living in the house along with a child. And when the parent passes away, the child continues to live in the house and make the mortgage payment and pay the property taxes, and the property remains in mom's or dad's name while the child lives there. In which case, then the child decides to sell the house 10 years later, and in which case we have to do a probate based on the person that passed away 10 years ago.
I see. Now, you probably hear about that. You work closely with the real estate community, that an agent took a listing and found out, oh, this person can't sell the house.
Yep, that's an interesting one. There's lots of timelines to follow with the probate too. So usually when you take the listing agreement is the time to figure all this out so that you can start the probate process correctly. Unfortunately, yes, I've been involved with quite a few where, interestingly enough, the way it usually happens is mom wants to sell the house. And mom comes to you and wants to sell the house, and then as you get to the part of the preliminary title report and the process that a good agent does down the road, you find out that uncle's on the property with mom or another person's on the property with mom who's now deceased.
Good point.
So it's not always a situation of the person who's on the house being deceased. Sometimes there's multiple people. Sometimes there were what we used to call co-signers. So maybe mom couldn't get a loan 15 years before, and an uncle helped. Now the uncle has passed away, and that would be another reason to do a probate. But to get technical in that situation, the probate would only be to 50% of the property.
I see.
Because obviously mom still owns her 50%, and let's say the uncle owns his 50% and he passed away. So the probate would be as to the 50% only. And that's important for calculating fees because probate can be expensive.
Okay, because that would slow down the process of a listing, and certainly I would imagine this happens a lot when there's already a contract, a purchase contract accepted by the seller.
Unfortunately, I've seen it come up at that point in time. And what people don't realize is that to get a probate judge to sign off on the sale of a property, it could take 45, 60, 90 days, 4 months, 6 months, depending on who's involved, depending on if it's amicable. I've seen heirs come out of the woodwork. I've seen people objecting. So depending on how smooth the process is or how complicated the process is, can add on to that time frame.
Right.
So it's really important if you have a probate that's involved with real estate, that early on you find a competent agent that can help you with the listing, and also find a probate attorney that hopefully has worked with that agent before, so there's a good working relationship, and build kind of your team that's going to help you sell the property.
Okay, now the other part of that is oftentimes the way I've seen it, the ones I've been involved in, there wasn't an attorney involved, and I was just working with the county and the employees down there. Is that a case where they did not have heirs?
Again, it depends on the situation. Sometimes the person could have been conserved.
That's true.
Where the public guardian's involved, and they may take over. And if the county's involved, then the probate may be handled by county counsel. So there may have been an attorney involved, but it looked a little more seamless because there wasn't another name on the paperwork. It was all done through county counsel. So it's really hard to say how it goes, but it is, I won't call it a complex procedure, but it is one you do need an attorney for. And the reason why is because you really can't, you can in some circumstances, but representing another entity or other individuals, you need to have a license to do that as compared to representing yourself.
Got it. Okay, you touched on about the heirs or relatives, and I know they like to stick their nose in the process, which fair enough, but some may go overboard. How should the family members proceed? Because they really don't have much say in the process, right?
They do, and again, it really depends whether they die intestate or whether there's a will or a trust or all these different items. If there's a will, some people do what's called a will contest. Maybe John, to use your example, only wanted to give $10 to one son, and the rest of the money went over to some other people, and then the son may come in and say, well, Dad loved me as much as he loved you, and the $10, it was because, unfortunately, a lot of times elder abuse and other allegations are made within these situations. I've had a prior case where the elderly person needed full-time care, and one of the daughters pretty much stopped her life completely, took care of mom for probably 4 years at home, 100% of the time, taking care of mom during her last illness.
Sure.
And so mom changed the house so that she received 100% of the house. And there was a son that didn't even call mom, didn't come out and visit her in the 4 years, and then the son ends up suing his sister for half the house because he made allegations of elder abuse, stating that you were taking care of mom, you were her caregiver, and you basically tricked her, intimidated her, whatever these words are, to be able to get her to deed the house to you and not give me my half.
Interesting.
So these types of things come up, unfortunately, routinely, and they cause some of the dissension that goes on.
I see. Now, in terms of avoiding probate, we've talked about that in the past.
Yeah, and that's obviously the way we look at it is probate should be kind of a last resort with any type of planning at all, and there's multiple ways to avoid probate. And one of the main reasons to avoid probate is time and money and just the hassle of it. For example, all the bank accounts get locked up. The property gets locked up. We've had situations where you have minor children that need money. Well, if you think about it, if dad passed away and the bank account was in dad's name, how does an uncle go get money out of dad's bank account to take care of a 4-year-old? And so you need to go into court and get orders from the judge allowing for what's called family support or all these other things that can go on. So all that takes time. So one of the main ways and the best ways to avoid probate is to have a living trust. And whether it's a living trust, a family trust, a revocable trust, they're all kind of the same animal. And they basically allow you to avoid probate. And the concept is when you pass away, since everything has been deeded or moved into this revocable trust or living trust, when you pass away, you don't really have anything anymore. And so we have somebody called a successor trustee that comes into play and takes over all the assets and then can administer the assets through what we call trust administration, which is similar to a probate, but it's out of the court system. So it's much more streamlined, it's much more efficient.
Done privately.
Done privately, done a lot of times inexpensively. So it's much easier to do that rather than having the probate. And that's the best way to do that.
You have also mentioned in the past about substandard practices of avoiding.
Yeah, so that's a very good way of putting it, Pat.
Yeah,
a lot of people, when it gets on in their years and they want to give their property to people, they do it during their lifetime. And the big law school word that we learned was inter vivos, meaning during your life. What people tend to forget are the tax consequences that can derive from giving away property during your lifetime. And for example, and the tax law is changing all the time and the state is changing all the time, but right now, if you pass away and you bought your property for say $20,000 and now it's worth $1 million, that difference of the $980,000, that's capital gains. If you just deed it to your child during your lifetime, inter vivos, then your child will pay capital gains tax on that because the basis is the same basis as the giftor. Okay? When you go through probate or a living trust, when the child takes the house, they take it at fair market value. So the day after they get the house in their name, they can turn around and sell it and pay 0 capital gains. So a lot of times people do things quickly and they don't realize the damage it can cause. Okay,
so that's the case. They weren't trying to do anything that would be illegal or unethical. They were just trying to do it quick and dirty.
Correct.
Okay.
And it's not illegal, it's not unethical. The challenge is you're just taking away a lot of the benefits that the government and the IRS give you and not understanding what it is. Another way to do it is what we call joint tenancy. So you probably see that a lot in your work where you see properties are held in joint tenants and tenants in common. A joint tenancy, and if you're married, you should look into joint tenancy with joint tenancy, community property with right of survivorship. Right. Which is like a joint tenancy for married people, and there's tax ramifications for that. But a joint tenancy, upon the death of one of the joint tenants, all you need to do is file a death certificate, and then half that property will revert to the other person. So for example, if John and his brother bought a piece of property together and they made a deal saying, we'll buy this piece of property, and whoever passes away first can take the property as their own, and then after that do it what they want with it, then a joint tenancy would be an excellent, inexpensive ways to handle that procedure.
Okay. Now, to review, people often say, well, he had a will, so we're going to avoid.
Correct, and that's just completely the wrong assumption. So remember, we talked about the table, the intestacy, where it goes to your kids and up to the. That's if you have nothing, okay? A will still goes to probate. So you still pay all the probate fees. And just to touch on those briefly,
Yes.
they're controlled by the court, and the executor gets fees, and the probate attorney gets fees, and they get equal amount of fees. And right now, if I recall correctly, it's 4% on the first 100,000, 3% on the second 100,000, 2% on the next up to say 900,000 or so, million, and then 1% on everything after that.
Wow.
So if you have a couple $1 million estate, we're not talking about a small amount of money. And then let's say it's $20,000, the probate attorney would earn $20,000 for handling the probate, plus any what are called extraordinary fees, and selling a home can be considered an extraordinary fee that is added on. And then the executor, who's actually handling the estate, the executor is the person's named in the will, they get the same $20,000.
Wow.
Where if you had a living trust, you may only pay like 5%.
I see.
So there's a significant difference in what it is, but that's just on the will. All the will does is if you all of a sudden wanted your property not to go to your kids, you didn't like them for some reason,
Right.
and you want it to go to your uncle, or I've done trusts and wills. I did one for a parrot one time.
A parrot.
Well, parrots live to be 70, and if you're
Okay.
if you're 60 years old and you get a parrot, you got to take care of them.
Yeah.
So the will would then divert and avoid what the intestacy laws may cause. So for example, you could have 2 kids, do a will, and give all your property to your brother. And
Right.
that would be a reason to do a will,
Right.
is just to change where your estate will go. But again, the trust is the best methodology overall.
Okay, you have mentioned in the past about if a real estate agent comes across a situation where it's going to be a probate, to get in early.
Yeah.
To get in early. I suppose you've seen it where they come to the party late.
Yeah, the problem is, unfortunately, in our court system, everything takes time. And everything takes a heck of a lot more time than what most real estate agents are accustomed to. In the real estate world, as you know, you call somebody at 9 o'clock in the morning, if they haven't called back by 11,
They're out.
you're calling them back again saying, what's taking so long? In our world, everything's 30 or 45 days because you have notice provisions that you have to mail out. So the problem is when you have a contract and we got to close Tuesday and you find out it's a probate, you make a lot of people very unhappy.
Right.
The other thing is when the judge finally signs off on the order that says it's okay to sell this piece of property, there's going to be a buyer's name on there. And that is what the title insurance companies insure off of. So when you go to your favorite title insurance company, whether it's Fidelity, Chicago, or Republic, whoever you go to, they're going to look at this court order and they're going to say, okay, the court has allowed this executor or this person who's handling the will to sell the property to Bill Smith. The problem I've had in the past also is let's say Bill Smith doesn't qualify for a loan. So then he goes out and brings on his brother, Jim Smith, to help him qualify,
Okay.
but they never tell the probate attorney. So now when you go close, the title insurance company goes, well, we can't sell it to Bill Smith. We have to just sell it to, right. So then you have to go
Yes.
back and change the order, and sometimes that can take another 30 days.
Okay, now because of the probate, there's a judge involved. The judge is really ruling the roost here in case a buyer got upset or you.
What happens most of the time, the rules of probate are so, I'll say strict or at least set out. If you have a good probate attorney, they should be able to navigate it so that your actual judge involvement is pretty minimal. For example, we submit all our paperwork and there's a pre-approved status a lot of times. So if you're good in probate, a lot of times you'll submit it, you show up to court, and it's already been stamped and signed, and they just hand it back to you.
Oh, okay.
So it's not so much the judge controlling it, it's more about what has been sold, whether it's been sold for a fair price, and whether the paperwork's been done correctly. And then also, depending on the will and the heirs and all these different items, what we try to do is, as long as everybody's working together, you can have the heirs, for example, waive out of bond requirements. So a lot of times in some probates, they'll make the executor go out and get a bond in case the executor steals money from the probate estate.
Correct, okay.
And so if all the heirs are on the same page, which usually are hopefully, they'll let them waive out of a bond. Or they'll let them get special powers when the letters are issued. So when you start a probate, you apply for letters of administration, and the court orders those, and some of those letters have more powers than others.
Okay.
So if you're able to get the right executor to handle it, and if everybody signs off saying, Pat's the guy to handle this for us, and all the heirs love Pat, then you can get special orders that will streamline the process.
Oh, I see. Okay.
If you have people fighting, then you have bonds in place, and you have more overbid requirements where the property has to be went into court, and then somebody in court could overbid your buyer.
Okay. Let's touch on that before we go here. When, let's say there's a for sale sign on the lawn, buyer sees it at the open house, if there is an open house, writes an offer with their agent. How do the agents, we got a few minutes here, how do the agents come together and make an offer? And
every good agent that is dealing with a probate, it should say in there, this is a probate sale subject to court approval, all this different verbiage in the MLS. So hopefully, and you don't know as a buyer's agent whether they have, what powers they have. So assuming they have the least amount of powers, then it may require court ratification, in which case the buyer makes the offer, and you got to tell them, you may not get this deal because somebody may go into court and overbid you. But there's an overbid formula. So if the house is 500, the overbid may be 530, or it's not like $1.
Sure.
So it has to be significant enough to make it worthwhile for the buyer that truly wrote the offer that he's going to get the house.
Now, I, of course, started before the internet, where we would write an offer and go to a kitchen table and present to the seller and the seller's agent that night and wait out in the car for an answer. But in this is not done over the email either. You have to write the offer, you put it into an envelope, you go down to the county building.
No, this is, again, work with your probate attorney.
Yeah.
You'd write the offer, you'd get into contract, and then there'd be contingencies, and one of the contingencies is court approval.
Right, but if there was 5 or 10 offers on a property?
Again, it would be up to the executor to pick what they would think would be the best offer.
Okay.
And then you'd apply for the court approval, and then there's a motion you have to do to approve the sale. So then the attorney would draft the paperwork to approve the sale, and then notice would go out to the heirs saying, we're selling this house for X, for Y, and then they could try to object. And then again, it's a published sale, public sale, and you have people come in and bid. I will tell you, in all my years, I've seen very few overbids in court.
Right. Now that's where they've pretty much gone through the sale, they go to court, and the judge asks, is there anyone here to overbid on this property?
Correct. So the procedure, just real briefly, is it'll be published so that, and if you go into the courthouse, because I know you love to go down there and visit all the time.
Yeah.
When you walk into the right, you go to the right over there, there'll be a whole list of public notices, and you'll see the probate sales and how much they're going for. So then you can go upstairs, and the idea is when you overbid, you take all the same subject terms as the contract. And then you also have to prove that you can afford it right there too. So then the judge will raise his hand and say, we have 123 Elm Street, we have a bid of 230, the next overbid is 253, do I have any bidders? And then nobody says anything, and then he goes, okay, and then he approves the contract as it stands.
And then they go ahead and close. So if somebody did want to do an overbid, for people watching, what is the mechanics on a situation like that? Would they have to have cashier's checks in their chest pocket?
Not necessarily, but if there's a 45-day close, they have to at least show with reasonableness that they have the availability to close within the same time frame as the original contract.
Okay.
So it could be a 30-day close, 45-day close. If your contract you're trying to get approved is a 5-day close, all cash, then the overbid would have to be the same 5-day close, all cash.
Now, would the people that would want to overbid, do they have access to the contract and the terms?
Not necessarily. It's written in the motion, so they'll have the access due to when you publish it, and when the motion's filed, they'll be able to see what the terms are.
A little bit of terms
A little bit, but that's where the risk comes. So my point is, if they're really interested in the property, they've already gone through that process. And especially if the agent's involved, they've opened it to the MLS, to the market. And so usually the equilibrium on the prices have been met. So there isn't a lot of room to overbid.
Can the original buyer then have an opportunity to overbid?
Again, I've never seen that.
Okay.
But yes,
All right.
it would be bidding where you could bid at that point in time.
To go back and forth.
Sure.
Okay. So in closing, any of the tips for probate, how to avoid it?
Again, living trust, if you own a piece of property in California and it's worth more than $100,000, you really need to see a living trust. And the parts that we left out that aren't directly related to the probate are, when we talk about living trust, it's usually a pour-over will, which is helpful, the advanced healthcare directive, durable power of attorney, everything to help you with those types of decisions.
Beautiful. Shawn Parr, Parr Law Group, thanks again for coming down
Thanks
today.
for having me.
You bet. Thank you for watching Kapowich on Real Estate. This is a program dedicated to consumer protection within the residential real estate arena. We will see you next week, same time, same channel. Thanks for watching.